Your case is coming up for trial and there's a knock on your door. You ask who it is and the person says they have a document for you. You open the door up, it's a process server. And you take a look at it, it's a subpoena to compel you to come in and testify in your own trial. Would you like to learn what this is about? Come join me as I share with you this unusual situation. Hi, I'm Gerald Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Your medical malpractice case, accident case, or wrongful death case is coming up for trial in New York. And all of a sudden, you open up the door to somebody who's been knocking and they hand you a piece of paper. Confused, you look at it and you see that it's your particular lawsuit, but it's a subpoena. It's a document that is compelling you to come into court and testify in your own trial. How bizarre is that? Well, let me explain how this happens. You see, as your case is coming up for trial, your attorney has to prepare your case, and there's a lot of stuff that goes on behind the scenes that you probably don't even know about. One of the things that happens behind the scenes is that your attorney has to prepare a document known as a subpoena, and they send those subpoenas off to various doctors and hospitals to compel them to send your records into the court so that now your attorney can use those records and get them into evidence to support your claim. What you probably don't know is that the defense attorneys, who are getting ready for your case as well, do the same exact process. And they send out subpoenas as well. They send them to the doctor's offices, they send them to the hospitals, again, for the sole purpose of getting those medical records into court, so now when your case is actually on trial, they can get those records into evidence and use it to support their position. But subpoenas can be used for something else too. They can be used to compel a witness to come into court and testify. There may be an instance where the defense attorney does not believe that you are voluntarily going to come in and testify at trial. In that instance, they are fully within their right to have a subpoena delivered to you, to hand it to you, and say, listen, we are compelling you to come into court and testify at your own medical malpractice or wrongful death or accident trial. Now, one of the key reasons why they're going to do that is that they want you to testify on their case. Remember, when you bring a lawsuit, your attorney is going to put on whatever witnesses and evidence is necessary for their part of the case. And when they're done, they're going to rest. And after they have rested, the defense attorney will then have an opportunity to put on whatever witnesses they feel are necessary to support and defend their claim. And as part of doing that, they are fully within their right to compel you now to testify on their part of the case. So this is just one little thing that goes on during the pretrial process as your case is now coming up for trial. And I wanted you to be aware of it. Why? Because I wanted to show you a little bit of an insight and an understanding into what goes on into the trial process here in the state of New York. You know, chances are you have your own questions and concerns, and if your matter happened here in the state of New York and you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions, and I do this every single day. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. So if you get that knock on the door with a process server saying, hey, Mr. Jones, I have something for you, don't be afraid. Take the piece of paper, read it, and then send it off to your attorney. I'm Gerald Oginski here in New York. Thanks for watching.